There is perturbation case item 1 WPL 5312 of 2025.
Why is it under training?
The WPL proposal was the last order investment FL.
This case has been listed at the instance of the office by pointing out that order number 3 dated, in order number 3 dated 27/4/2026, instead of WPA number 5312 of 25, FA number 5312 of 25 has been mentioned. Peruse the records. The order dated 27/4/26 is hereby modified, and FA number 5312 of 25 as printed in the same ownership is directed to be read as WBN number 5312 of 2025. Office is directed to carry out necessary corrections in the order.
For final disclosure item 2 WPL 2256 of 2019.
Last step, we were directed to seek instructions from the client regarding the offer that was made in mediation. We have sought instructions in mediation. Whatever they are offering, she's not available. She's got 2 daughters that she needs to have.
No problem.
That's
Are you the
very issue, but date may be fixed my senior was in the matter. Because there's a point of maintainability issue that was raised, wherein they are saying that I was appointed at the post of a manager. My case is that I was not at the post of manager, no disciplinary proceedings. After 1 year, they have simplicity terminated me. That too not in accordance with my appointment letter. Their case is that I was on probation and thereafter they have terminated me. And the fact that they state is that I was appointed at a managerial position. So whether or not I was at a managerial position or not is the point that needs to be simplified.
And on merits, you were appointed as a probation.
Merits, there is no adjudication because it has been had to be not maintainable, so that issue was.
Yes, it was never decided.
So it is in their interest if it is decided. At best, they can get a remand. Any date will be fixed. We are ready. So it is in the pilot disposal. I think some offer 1.5 lakhs or
Yes,
something.
was offered.
A short period of employment, 2016 to 19. That is why I spoke to the officer.
But the salary
Where is
last
the
was
finding?
49.
Where is the finding?
Finding is on page 103, para 12, page 12 and para 12 of the paper. Finding starts there.
We have option establishment of
Read with item number 5 in the first sheet.
So maximum 10% could be exempt.
Maximum.
But you did not submit the list of
We did not get the list.
employees.
Yes.
Okay. You must have got yourself registered under the Shops and Establishment
Yes.
Act. What is the number of employees mentioned there?
Usually the evidence it has come that there were around 20 people in that establishment. OPW1 and OPW2, and he was the senior most, topmost officer in the office, and that is why the Labour Court has given a finding that since he was the topmost in that establishment,
So
therefore there is not submission of the list makes no difference to the 10%.
I would like to point out that that is not the finding. The finding is saying that he has admitted he is a manager, and because he is admitting that he is a senior executive drawing 41,000, therefore he is a manager. Although the Labour Court goes to find out that he has said that the witness was admitted that Sandeep Singh was manager and he was executive, and that another manager from Bihar and he was working as per direction of Sandeep Singh. I am Amar Kumar. He is saying manager is Sandeep Singh. At page 104 it may be seen in leadership. And in fact in my writ petition I have given a categorical statement that I was working as 11.5.
read the findings.
Para 12. In the light of above mentioned respective submission of the learned counsel and opposite party, first of all I take up issues number 1 and 2. On these issues, most important witness is Amar Kumar, complainant himself. Complainant was examined as AW1. As per this witness, this case has been filed by him for setting aside order dated 27/6/2015 of the corporate manager HR, which was communicated to him after 1 year, which is 27/6/2016. This witness has admitted that it was offered post of senior executive by virtue of offer letter dated 15/5/2014 and consequently appointed on the same post by virtue of letter of appointment dated 22/5/2014, and he was getting gross salary of 41,250 per month. It has also been submitted that he was working from the Ranchi office and it was headed by opposite party number 2, which is circle head. As per this witness, his main job was to acquire land throughout the state of Jharkhand as per the requirement of the clients and to do all formalities with regard to lease agreement. So, as per the statement on oath, he was appointed as senior executive and he was getting salary of 41,250. So, admittedly, complainant was senior executive/manager. As per cross-examination of the witness, he used to get prepared documents regarding acquisition of land on lease and various no objection were also obtained by him. Lease deal was got executive on the prescribed format pro forma of the company. It has also been submitted that he did not put signature on the lease deal, but it was signed by circle head. This witness has also stated that there was another manager for Bihar and he was working as per direction of Sandeep Singh. This witness has submitted that Sandeep Singh was manager and he was only senior executive. So, in the light of above mentioned fact, now question is whether he was employed as per section 2.4 of the Act. From perusal of section 2.4, it transpires that an employee is a person employed for wage, including salary, etc., in connection for any establishment, and it includes apprentice and however, it does not include employers. It has also been provided that it does not include person employed in a factory who are not worker. Moreover, another significant provision is section 2.5 of the Act, and as per section 2.5, employer means a person who owns or exercises ultimate control over the affairs of the establishment and includes a manager, agent, or any other person in the immediate charge of the general management. So, from the conjoint reading of 2.4 and 2.5, it is very much clear that a manager cannot be employed, and if manager is not an employee as per section 2.4, benefit of the Act cannot be claimed subject to provision of section 4.2 of the Act. As per section 4.2, notwithstanding anything contained in this Act, the provision thereof specified in third column of the schedule shall not apply to the establishment as persons or persons referred to in the corresponding entry in the second column. From perusal of the notification of Jharkhand government issue under section 4.2 of the Act and as per item 5 of the schedule, if 5 or more persons were employed by any establishment, it would not be applicable to those employees who are doing managerial or supervisory work. So, as per item 5 of the schedule 1, if a person is doing managerial work, no provision of the Act shall be applicable. There is further provision in the item 5 itself that a list is required to be submitted by the management in whose favor exemption is required by the management. However, now question is what would happen if no such exemption list has been made available by the management. As per the submission of the learned counsel of the opposite party, it is a mere procedural matter and is not mandatory. On the other hand, learned counsel for complainant has submitted that since no list for exemption has been made available, so Bihar Shop and Establishment Act would be applicable. However, from perusal of section 2.4, section 4.2, along with item 5 of first schedule, along with proviso, I find that there is no provision what would happen if list has not been submitted by the management. It is a settled principle of law that if legal consequences has not been provided in the act itself, it would be treated to be mandatory rather than directive. It would be not be treated as mandatory rather directive.
Yes, what is this? He has been termed as a manager only because he is designated as a manager, as per the findings.
This evidence.
No, what we are not here to appreciate the evidence, but the point is that
If the finding is against the, it is not a question of evidence. The evidence is there, which says that she was the topmost. That the
which
petitioner was
evidence?
the topmost.
Which evidence? Where is the discussion of that evidence?
The evidence. This is the finding is based on admission that he was the manager.
So that is immaterial. That is immaterial. How does that make a difference? He has also disclosed as to what work he used to perform.
Yes, the work informed
So
the entire land acquisition.
so therefore, under the provision of your 5.2, right, you were supposed to give a list declaring that these are the persons who are to be treated as manager and 10% of those persons could be treated as manager. So it was very clear in black and white that these are the managers and these are the employees, which you did not do, right? So merely because he is termed as a manager and merely because there are 20 employees, how does that
No,
make a
it is not
difference?
merely. Let us see the evidence.
Let us see the evidence. Where is it?
The opposite party. Evidence is 65.
Yeah. Where is your WS?
WS is Annexure 2, page 38.
What is the name of this employee?
Amar,
He has been examined as a witness,
yes,
as PW.
one.
Where is his deposition? And where is your WS? Show me your
My
WS.
WS is Annexure 2 at page 38.
Please place your WS first.
Yes. Para 2,
Page number 38.
page 38. Is the WS.
Which paragraph do you want to say that there were 20 employees and he was the head?
The para 2 is the objection is there that he was doing managerial
That's right.
matter.
That is there. Where do you say that there were 20 employees and he was the head?
That is the evidence.
The evidence is so.
No,
How will you do it through
pleadings
evidence?
does not require the manner
No,
of the
no.
ground is taken.
The point
evidence
is,
can
the point is that, you see, at least you did not disclose how many employees you have. You do not disclose who would constitute amongst the 10%. In the pleading also, you do not say that how many employees were there. And do you say that he was the head of the organization?
Yes, we said in the Ranchi establishment, yes. The doctor. That is the evidence.
No.
And
Is
therefore
there,
we
is
said-
there any such statement in your WS?
In the WS, there is the grounds have been taken in that for exclusion. The evidence is separate. The evidence.
Show me, no, where is that exclusion? Which paragraph are you referring to? And what was the nature of work he was
Para 11.
performing?
Para 11. Yes, that also I have. I'll show. Para 11, page 43.
Read it, please.
That management department head of the opposite party company during the period so and so has explained possible support of the company. The duties have been given in paragraph 19. That will clear. And I may place para 2 also. Then if I may first place para 2 because the question came, he was the topmost, whether it is stated in WS. It is in para 2 of the WS. In the lower part, there is, he was the topmost officer in the establishment at Ranchi. This is the Ranchi establishment case, and as per his own admission, there was only one person from the Bihar who was superior, to whom he was reporting. Paragraph 2, that at the very outset it is stated that the complainant is excluded from the purview of applicability of Jharkhand Shops Establishments Act for the reason of being excluded under the provisions of section 4.2. He was appointed and has been employed in the opposite party company at all material times in the managerial cadre of the company. He was discharging duties, functions, responsibilities akin to that of a manager. He was the topmost officer in the establishment. And so far as the operational field of activity of the opposite party is concerned, not coming within the coverage of the sector. And then his duties have been specified in para 19. That paragraph 6 of the complaint petition is also inaccurate and incomplete. The duties, functions, responsibilities and powers of the complainant were as under: new site acquisition, sharing of existing sites, NOC from local bodies, statutory compliance at sites, resolving of day-to-day issues, not limited to the owners, neighbors, operators, local body issues, etc. Initiating appropriate legal action with respect to day-to-day affairs of the company, meeting requirements of customers, telecommunication operations, identification and finalize scope of work, commercials of work to outsource to vendor. He had the authority and used to process the leave applications, recommend for acceptance or refusal of leave, and submit recommendations regarding increments or promotions of all the persons working in his team and under him. He used to give directions, instructions to persons working under him, including field staff of the opposite party company and also vendors to get assigned work completed and who used to work so under his guidance. He also interacted with customers and outsiders. Interactions on the basis of final decisions were taken by the regional. So far as this establishment is concerned, he was the top. And it has to be seen establishment wise. The circle head to whom we mentions in paragraph 23 does not have any seat in Ranchi office. The circle head operates from Patna and he is the regional.
So therefore, at best you can say that the court has confined itself only to non-filing of the details
Yes.
and the designation, and has not appreciated the other materials placed on record. Right? Other materials in the sense that he was the head of the organization in Ranchi office, etc.
The judgment does not delve in full depth to the evidences on record, what para, what
Then
witnesses said, but nonetheless, the material.
no, I have not finished. So therefore, the findings does not take into consideration all the materials placed on it. It has only selectively considered the materials and returned a finding. So therefore, what is the remedy? Should I here decide appreciating the materials and hold that now there is a finding, now there is a material that you were that he was the head, or it has to be remanded? Still, it has to be remanded. You see, you can support the finding by referring to other materials, which does not form a part of consideration by the learned court while coming to a conclusion. So, under 227, are we supposed to appreciate that and return a finding that, irrespective of the finding, whatever the court has given? That is not possible for us, no, in this, because there may be some evidences, some your evidences, some their evidences, some cross-examination, some documents which might have been produced. You have enlisted a number of activities which were being undertaken by the petitioner, but have you produced any evidences? These are the things which are required to be considered, irrespective of the fact that the list was not provided and his designation was manager. Isn't it? Then also it has to be remanded.
His designation was senior executive, never the designation was manager. They have said manager, but he was always senior executive.
Whatever it is, but the court has only considered two aspects. Primarily, his designation. The other is that the required details were not furnished.
And his admission that he was doing the lease related work on the paperwork.
That's right. His admission.
His admission is the basis. That is why the
Lease
Labour does
related
not
work.
see my evidence.
Rather, lease related work. Right? It's a very wide.
So he had the power to negotiate, and because
But he never signed on behalf of the company.
the entire
That has also come.
the entire land acquisition, his complaint will be seen what he himself says.
The point is that why should I record a finding on the basis of what was the complaint, what was the evidence?
So if it is otherwise sufficient on the basis of admission, then the only point which I would need to address is that whether the non-supply of list is fatal.
No, it's not like that. If the court comes to a finding on the basis of selective appreciation of materials placed on record, and there are materials on record which could otherwise support the findings, but the finding of the court is not deliberating upon those evidences based on record. So should we decide it and consider the evidences based on record here for the first time in 227? Or we have to ask the court to consider every aspect of the matter, every evidence is put by both the parties, and then consider it. Just tell us. Just simple. If you satisfy us that irrespective of whatever be the materials which has been taken by the court into consideration, that is the full stop.
I would only submit that the Labour Court has relied on some part of the evidence but has not examined the entire aspect in totality.
That's right.
But has, on the basis of some of the petitioner's admissions, come to a conclusion that it is sufficient to establish that he was in the managerial cadre and he was discharging managerial functions and was therefore not an employee under the Bihar Shops and Establishments.
The court has taken two things. One is the designation.
Yes.
Other is that his own admission. From where do you derive his admission?
The complaint itself, let me begin with the complaint. What has been stated? Some portion. The complaint is at page 20.
20.
29. Page 29, he himself describes paragraph 6. That his main job was to acquire land throughout the state of Jharkhand as per requirement of client service providers to do all the formalities with regard to lease agreements and resolution of all the estate issues. This is his own statement in the WS, in the complaint petition. Page 31. So the employee himself discloses that he is the one go-to person for all the land acquisition work, which is essentially a managerial work. It involves various negotiations with all parties, including officers of the state.
Para 11 may be seen. He goes on to say who is the head of the establishment.
Is the head of the establishment is maybe outside, but
Being the head
it
of
has
the
to be
person
seen
in
establishment wise.
of the general manager or ultimate control of the establishment in addition to opposite party number 1 and 3, who are the persons who exercise ultimate control of the affairs of the establishment and hence are employers within the meaning. And also in para 4 he says that after his appointment he continued to work and achieve the best satisfaction of his superiors.
So superiors are
And he has
there.
never signed any document. That has also come. They have admitted it that he did not have the power to sign any documents on behalf of the company.
No, only the lease. Only the lease was signed by the regional. He had no power to sign any documents. Only the final document was signed, but the entire negotiation work, everything was under his control in the Ranchi establishment. This is clear cut
If a
admission.
person is negotiating, he becomes a manager.
He becomes a manager because it requires skill, it requires bargaining skills, taking decisions, making offer for money.
He will not take a decision. He will only collect the offer.
But
Some
he's saying he's doing
negotiation.
everything on his own.
On his own means.
He's not saying that I used to only convey. He's in his paragraph 6. He's describing his own job that he was the person at Ranchi who did everything. So far as land acquisition is concerned. Except he goes on to say I did not sign these. The signing part was done by the RM.
Ultimate decision was with the RM.
He was the signing authority. He does not say the ultimate
Signing
decision.
authority means RM will dance to his tune.
No, he has to formalize and he has to finalize and then he'll come and sign the execute the document.
No.
And
He has nobody to finalize. Land acquisition matters to
in
me.
their statement they have stated that final decision on basis of my interaction will be taken by the regional manager of the company.
Naturally, somebody has to do the dirty work on the spot, negotiating with every person.
That is
Then
managerial.
collecting.
That requires skill. With due respect, that requires skill. That is not a clerk's work. That work cannot be called a clerical work. That is the managerial work. And he's himself mentioning that the superior.
on that selective portion of his admission, right? The entire judgment will be made.
No. This is first of all his own admission. Then his evidence is also.
That how do we appreciate the tribe? The labor court has not appreciated the materials. There are so many nuances, whether a person is an employee or a manager, there are so many angles and minute angles to it. It requires a lot of appreciation of evidence. Isn't it? Mr. Bakshi?
It does.
It does.
But
It does. There is so much.
since it is on the point of maintainability.
Therefore, this point of maintainability also has not been properly decided. This is what I am indicating. But this time we will say that all the issues are to be decided. Selective nahi hoga. Whatever be it.
Leadership, the Supreme Court judgments are there that if you are holding not maintainable, then if you give a finding on merits, it will prejudice the other party because if it is suppose decided not maintainable, and that is why they.
We are coming across matters where it is held not maintainable, like reference is maintainable or not, right? And ultimately, what happens? You get the entire like the suit is maintainable or not, right? So every issue is being decided. And ultimately, if it is found that a suit is not maintainable or to have been filed somewhere else, all the findings
So here
that
also
we
the evidence was recorded on all the issues.
go on all the issues.
On all the issues, but because it was decided the issue
ये
of
शॉर्टकट तो नहीं
maintenance-
चलता ना, लेबर मैटर्स में ऐसा शॉर्टकट नहीं चलेगा. छोटा छोटा चीज को लेकर यहाँ पे चले आएंगे तो कैसे चलेगा? लेबर कोर्ट्स आर सपोज्ड टू डिसाइड ऑन द इश्यूज जस्ट लाइक अ सूट.
But here, because it was against the worker, it would have only prejudiced his case.
You see, I can understand that the court could have framed just one issue, that is maintainable or not, and had taken a decision. On all the issues, the evidences were led, and while holding that it is not, he's a manager, the materials have also not been considered properly. There is no finding on other materials.
On the other material, there is no in-depth discussion of the evidence, but on the basis of admission, they have come to the finding that and the other issue which was raised was whether the non-submission of the list would we presume that the workman, he has to be treated as an employee for the purposes of the act by non-submission.
And
That issue has been
if
decided.
you say that on the, so far as this establishment is concerned, he was the head of the establishment.
He was the topmost officer in that establishment.
What is the area of operation of that establishment?
That it will apply for Ranchi establishment and therefore Ranchi.
So
or maybe
every
beyond-
establishment in the state of Jharkhand is required to be separately registered.
Yes, all the establishments.
Please show me one provision that the separate establishment, there is any area of operation so far as the establishment is concerned. Or the certificate granted will be applicable for the entire state of Jharkhand.
Establishment itself has been defined. And the provision for registration of establishments is in section 6.
Let us see what is the definition of establishment.
Yes, the definition of it. Subsection 6. Establishment means an establishment which carries on any business, trade or profession, or any work in connection with or incidental or ancillary to any business, trade or profession, and includes administrative or clerical services pertaining to such establishment, a shop, restaurant,
Then
residential.
why a zonal manager should not be included wherever he is placed?
Because the zonal manager is in Patna. If the zonal management is an establishment, is treated as an establishment.
Is it a separately registered establishment? Because as I understand, for one unit, you see, in a particular state, the units are taking registration only at one place in the state, not at multiple places. And there is no requirement under law that at different places you have to undertake different registration as establishment, although they fall within the state.
Here it is even outside the zonal
That's right,
manager.
I understand. You see, in Kolkata there may be one more registered under the West Bengal Act. In Maharashtra there will be a registration under the this Maharashtra Act. But do you have provision of multiple registration of establishments within one state? There is no concept of area of operation. There is no concept of area of operation.
There is no concept of area, but there is a concept of establishment.
That's
Wherever
right.
there is an establishment.
And the language is
instance,
so wide.
If my
You see,
employee is
the
going
language
to
is so
Palam,
wide
yes.
that in connection with or incidental or ancillary to any business. And you are, this petitioner is reporting to a person at Patna.
who's not who's cannot come within the state also.
No, what is that? What point of time he was there?
It is of 2016 onwards, after the creation.
He was reporting at Patna. He was reporting at Patna.
He is saying that I was reporting to one person who was operating from Patna. Sandeep was the manager from Patna. So there is nobody in the Jharkhand office he is reporting to his superior. So far as there is no establishment and the employees go outside and work, there is no problem. But as soon as, just like a municipal trade license, the moment you open an office and if you have employees, then there is a requirement of registration. Section 6 says registration has to be provided by the owners.
I was looking for it one day, I could not get any area of operation. There is no provision of any area of operation so far as the registration certificate is concerned. So as to mandate the company to have a separate registration for separate place within the state, within the same state. But you say that he was reporting somebody to somebody who was stationed at
Patna, which was beyond the territorial jurisdiction also. The Jharkhand. Group 3 provides for registration. This is the Jharkhand Shops and Establishment Rules 2001. Rule 3 says the language is every employer shall, within 30 days of the application of these rules to his establishment, make an application in duplicates also. So in relation to his establishment. So wherever there is an establishment, although it has become very difficult to confine it in the present age when people are working on laptops from their homes, but when the act was conceived, it signified a geographical location, an office, a place from which the company would perform its
you
operations,
see
and that was an establishment.
in various legislation, including taxation, there is a clear provision that even a branch office is required to be separately registered. There is a clear provision. But in all these acts, we do not find any such provision that even different establishments, and there is a concept of consolidated registration also in those statutes, that there can be a consolidated registration. Here there is no such concept, nor any area of operation has been defined, nor it can be defined. If a person is actually reporting, suppose somebody comes to Jamshedpur or goes to Dhanbad for doing some work, or maybe that he is stationed in Dhanbad saying that there is lot of work over there, you please live there only, why do you have to come down, up and down again, not required. So he will be excluded from the establishment.
But since the establishment is in the act says establishment, and in fact practically also we are facing these problems even for such employees, we are getting compliance notices that the employee has to be attached to. If it is, then we'll see the letter of appointment and we will tag him to that
Certainly
establishment.
attached means he is reporting to somebody.
Yes, so he has to be attached not to the employer, the person, but to an establishment, because the registration is of the establishment.
That is why the list
And
of
not the
that is
employer.
why the list of employees was required to be given. That is why the list of employees relatable to a particular establishment was required to be given. But that compliance you have not done.
Irrespective of that compliance, because we've said that he was the topmost in the Ranchi establishment, and therefore there is this.
Even in the evidence, this aspect has come. Even in the evidence that he was the topmost in that
Yes,
establishment.
OPW1, OPW1 para 1 only. Next one, page 16.
Page
Page 16. Para 1 that I am presently serving as page 71.
yes.
That I am presently serving as assistant manager HR, Bihar Circle of the opposite party number 1 company, and am conversant with the facts here. Amar Kumar, who has filed the present case, was working in the opposite party number 1 company in the managerial category, was discharging duties, functions, and responsibilities akin to that of the manager. In the Ranchi establishment of this company, Amar Kumar was the topmost officer in the operational field of activity. Moreover, the appointment of Amar Kumar in this company was on probation. Second is this, then paragraph 4. Amar Kumar was the face of the opposite party company. He used to interact with the owners, vendors, municipal authorities, panchayat authorities, legal bodies, administrators and government bodies, customers and other individuals, and others with respect to the affairs of the operations. And then we are producing the documentary evidence. This is a copy of the intimation of an accident incident at the site to the insurance agencies. Copy of another email so and so sent by furnishing the insurance company details. Another email regarding insurance again. Follow-up copy to the police department in Hazaribagh. Shows his areas of operation confined extended to all over Jharkhand. That is the evidence that he was dealing with all over Jharkhand. Then copy of another letter written and signed by Aman Kumar to SHO Devghar in connection with support for shifting of telecom tower equipment lying at Devghar. Then copy of letter written to Amar Kumar and signed by him addressed to the officer in charge Latur police station. Communication regarding some correspondence regarding some notice sent by advocate. Then copy of another email containing his instructions for execution of documents on stamp paper with site holder. Another email dated so and so his instructions for execution of supplementary agreement. This is a copy of it for approval from corporate office for further processing of site activities.
So, Mr. Bakshi, on the basis of his designation and on the basis of his admission, it has been held that he was holding the post of manager. So far as the other evidences which you are saying, which has been placed, including the oral and documentary, have not been considered. Your specific case that he was the topmost person has also not been considered. So, these evidences which you have placed on record is required to be appreciated. Is there any scope under 226 to appreciate this and come to the same finding? At best, you can say after appreciation of this, it will boil down to the same finding. They will also say that they have given so much of oral and documentary evidences, and they will also place the cross-examination. So the scope of writ to restriction will not extend to such an extent. We will just indicate the perversity of non-consideration of materials and remind it back. And fight it out there.
should we indicate that it is not a small, it is a proper speaking order?
It's not a proper speaking order. It has not considered
All
the
issues
materials
will be-
on record. And I will record your submission that these are the materials which you are wanting to show, and you are asking for this court only to appreciate this. There is no scope.
And Worship may remand it, and I would also say that it should be, it can be either an open remand or only at the stage from
No, I
which
will
arguments.
not an open remand. It will be
From the
since
stage
the-
of arguments,
from the stage of arguments. Your all the issues to be considered
from the stage of arguments.
from the stage of arguments. That should be sufficient. There is no question
At
of
least
any
it will cut
further.
short the litigation.
Yes, certainly. There is no question of any further because the parties have laid evidence on all the aspects
And
of the
they have
matter.
already examined witnesses. And in fact, the original petitioner has lied during the pendency. So at the stage of argument, it
Original petitioner has been substituted.
yes, by his wife and daughters.
During the pendency of this case.
So ultimately, what we boil down to is some
Back
kind
pages.
of consequential relief. If ultimately it is found that he is an employee and all these things.
If he is an employee and if the termination is illegal, then back wages or compensation.
So your litigant is not interested in any kind of
They are only ready to pay the due, which is travel expenses and 1 month salary. That is all they are paying. And she's got 2 daughters to look after. One
I
of
think
them
it was
is a law.
1.5 lakhs.
Yes, 1.5 lakh, 72,000 odd rupees is what is admitted that they have not paid traveling expenses.
That is excluded. That is otherwise also payable. Admissible amount.
But they are saying we'll pay everything included 1.5. And she has said if I get close to 8 lakh rupees, at least I can secure my daughter's education for the future.
Not acceptable to you. Absolutely. Suppose it is held. Ultimately, you win that it is not a. He was in a managerial capacity. Still, their right to litigate will continue.
To the extent of back wages, it will.
It will.
That is
Because they
she
will
was substituted.
then they will litigate in some other forum. It's not that the rights will not die down, Mr. Bhatt.
Yes, yes. We can go to civil court. If there is no other
No
labor
other
law
forum,
protection,
we
then
can go
civil
to
suit.
You
And
want to
civil suit
fight-
is never for reinstatement, it is only for damages.
That's right. Whatever it is, so in spite of you, they are not ready to compromise.
In this
In
case,
spite of you.
No, we've tried our best. It has been referred to mediation, but the company is saying the period is also very short. And since the death is also subsequent during the pendency of the litigation, otherwise the company would have considered. Otherwise the company, what usually pays, it's an infrastructure company providing mobile towers for various telecom companies.
So
Based
you
in
want
Hyderabad.
quite a bit, isn't it?
it was simplicity termination. One email and my job was over.
On that, the company's whole defense is it is under probation, but there is no finding on those issues, whether it was stigmatic, not stigmatic, all those aspects. Admittedly, there was no inquiry, but we are saying it was not satisfactory, which is being treated as being stigmatic.
Heard the learned counsels appearing on behalf of the parties. District petition and Article 227 of the Constitution of India has been filed challenging the judgment dated 21/1/2019, given that it NH 6, passed by the presiding officer, Labour Court Branch in Bihar Shops and Establishment case number 10 of 2016, whereby the petition filed by the original petitioner under section 26 of Bihar Shops and Establishment Act 1953 has been dismissed. The original petitioner had expired during the pendency of this petition, and consequently he has been substituted by his wife and children. The learned counsel for the petitioner has submitted that the original petitioner namely Amar Kumar, claimed to be an employee under the respondent within the meaning of Bihar Shops and Establishment Act. And he was offered the post of senior executive by virtue of letter dated 15/5/2014, followed by letter of appointment dated 22/5/2014 in Jharkhand, having office at Ranchi on gross salary of Rs 41,250 per month. She submits that the main job of the original petitioner was to acquire land through the state of Jharkhand as per the requirement of his clients / service providers, and to do all formalities with regard to lease agreement. And the original petitioner was an employee.
Was posted as senior executive level 5. As
He
per
was
appointment.
posted as senior executive level 5. He was abruptly terminated on 27th of June 2016, and ultimately the case was filed under the Bihar Shops and Establishment Act, challenging the order of termination 2016 को है ना?
Friendship 2016 में communicate हुआ था,
हाँ.
और जो letter of termination है 15 का.
हाँ,
Same date.
right.
Actually, it was a
And-
typographical error.
That was their claim, but that was never decided.
But the letter of termination, which was subsequently communicated to the original petitioner, is dated 27/6/2015. It was a specific case of the original petitioner that the order of termination was stigmatic and was issued without following the mandate of law, which has affected the future course of employment, and no proceeding was drawn prior to the order of termination. The notices were issued to the respondents hearing by the learned court, and as many as 5 issues were framed, including the issue as to whether the complainant is an employee within the meaning of section 2(4) of the Act. And other issues were also there on the point of and the legality and validity of termination from service of the complainant was also one of the issues on merits. Para 4 को issues को quote करेंगे. The learned counsel submits that the parties led both oral and documentary evidences on all the issues. However, the learned Labour Court Ranchi has decided only one issue by holding that the original petitioner was not an employee within the meaning of the aforesaid act and was holding a managerial post. And ultimately held that the petition itself was not maintained. The learned counsel submits that the findings of the court with respect to issue number 1 and 2, which alone has been decided, is in paragraph 12. And the learned court by has only selectively considered the materials on record and observed that the original petition had admitted
He's never admitted, the manager that he has admitted that I was doing all the work related to
had admitted that the original petitioner was doing all the work relating to land acquisition and therefore
and was getting a salary of
and was getting a salary of rupees 41,250 designated as senior executive and therefore he cannot be said to be a manager within the meaning of the aforesaid act. The learned counsel has also submitted that although the learned court has recorded that there was complete non-compliance on the part of the management in as much as the management did not furnish the list of the employees who were to be exempted under item number 5 of schedule 1 of the aforesaid act.
required for some.
But in spite of that, the court has observed that the petitioner was the original petitioner was working as a manager. The learned counsel has submitted that the learned court has not taken into consideration the materials placed on record, both oral and documentary, while coming to the finding, nor has decided the case on merits. She submits that on account of non-consideration of the materials placed before the court, the impugned order cannot be sustained in that sense. And therefore, it calls for interference and the matter be remanded. She has also submitted that since the original petition has been substituted, there is no further need of any, and and full evidence was led by both the parties. There may not be any need for.
That part we got recorded as sounds.
That's the last sentence. The learned counsel for the opposite party has submitted that there are materials on record to show that the original petitioner was working as the head of the institution, head of the establishment, and therefore, further numerous documents were also placed by the management to show the nature of work being performed by the original employee. He submits that the evidence of the sole management witness reveals this aspect of the matter.
The two managers.
You are referring to NW1? The evidence of NW1 reveals this aspect of the matter and reference to numerous documentary evidence. He submits that upon considering the materials which has been led by the management, there can be no doubt that the original petitioner was working in managerial post. However, during the course of arguments, it is not in dispute that the materials which had been placed on record from the side of the management, particularly the documentary evidences and also the oral evidences, have not been considered by the learned Labour Court while coming to a finding that the original petitioner was working in managerial capacity. It cannot be disputed that not only the evidence of the management was required to be considered, but also the evidence of the workman was required to be considered with respect to both oral and documentary, with respect to the nature of work being performed by the workman, to come to a finding on the issue as to whether the workman would qualify as an employee within the meaning of the Aforesaid Act of 1953 and the rules made therein. This court, upon going through the impugned order, finds that the learned court has not done the needful inasmuch as the materials placed on record have not been considered in totality, and only some of the material have been considered while coming to the finding that the original petitioner was not the workman, was not the employee. In view of the aforesaid facts and circumstances, this court is of the considered view that the impugned order suffers from perversity on account of non-consideration of the materials placed on record from the side of the non-consideration of many of the materials placed on record from the side of the original petitioner as well as from the side of the management. This court is of the view that in exercise of power under Article 227 of the Constitution of India, there is no scope for this court to appreciate the materials and come to a finding. Primarily, this is the exercise to be conducted by the court concerned. Having said as aforesaid, the impugned order being perverse cannot be sustained in the eyes of law. Accordingly, the same is set aside. The parties are directed to appear before the learned court. I will give a date, 4 April. It is further directed that upon appearance of the parties, the learned court shall do the needful and pass fresh order considering every aspect of the matter and also decide all the issues which are involved in the case. That is sufficient. The needful be done within a period of 3 months. All the issues which are involved in the case based on the materials already placed on it. Needful be done within a period of 3 months. The court shall also legal aid with them.
I'm not aware of this. If she sees legal aid, maybe not.
Uh, in case the petitioners need any legal aid, the court shall do the needful so that and appoint a legal aid counsel.
The reading for orders item 3, FA 1117 of 2022.
IE for
10184 of 2025 and filed as the additional evidence also. This may be considered at the time of hearing also.
they must have responded to it.
Worship, in this IA 101-4 of 45, Worship, an order has been annexed by the petitioner, Worship. That is the order of neglected Restart Cooperative Society.
Removal of the respondent number 1 after due to the pendency of this appeal also. This may be considered according to judgment of the Honorable Supreme Court 2012 SEC page 148.
This order of the cooperative Restart Cooperative Society is also under challenge, Worship. It has been challenged by the WPC number Worship 1285 of 26.
That is the separate.
No, Worship. That is also connected issue, Worship.
इसका क्या होगा? This itself is an appealable order. Writ में क्या होगा? What are you doing in the writ?
It had been appealed before the Lordship Minister, and Minister has also dismissed the matter, Lordship. Thereafter, along with this order, the appellate order, Lordship, has been also challenged before this court. We have also moved before the Honorable Minister, Lordship, in this matter.
How does this order becomes relevant? During the pendency of the suit, the matter was
During
pending.
the pendency of this appeal also, the respondent number 1 also has been removed from the post of secretary also.
So,
Is the contesting
maybe contesting means that he is not contesting in his individual capacity, is he? How does that make a difference?
Not see the same is executed in favor of the defendant number
It is
1
immaterial.
and the plaintiff lordship is the plaintiff lordship. The respondent number 1 is the plaintiff lordship. He filed a suit for cancellation of my sale date. Suit was decreed against which lordship this appeal has been filed before this.
Very well. You see, today there is a person at the head of the institution. He will execute many documents, right? And then some order can be passed. And has it been? He has been removed as a secretary.
That may be considered at the time of hearing according to decision of the Honorable Supreme Court of 2012 8 SEC page 148 paragraph 41 the additional evidence is to be considered at the time of hearing lordship. May be considered at the time of hearing lordship.
Lordship, while this case lordship which
That time lordship may pass the appropriate order at the time of hearing lordship.
Lordship, this case 1285 or 26, if this case is considered before this court lordship and this order will go, then I will be agreed that
1285 of
2026 lordship.
what is it?
We have challenged this order lordship, which it has been alleged by the petitioner lordship.
So how this order will go? This order cannot go.
He is saying that I should be removed from the Arab party lordship.
No, there is no question of removal. That is not his case. He says that this should be considered as an additional evidence. There is no petition filed for deleting his name.
No, I am not filing.
You see, the litigant is not the private party.
This
Litigant
lordship,
is
the
not the
order
private
has
party.
been challenged lordship.
So what?
Possible.
अरे भाई सीधा सा बात नहीं समझ आता. आज कोई प्रेसिडेंट है, कल कोई दूसरा प्रेसिडेंट बनेगा, तो पुराना प्रेसिडेंट का ऑर्डर का सेट असाइड हो जाएगा. Then how does that make a difference? The institution will go on.
Yes, lordship.
If I am not there,
Somebody else
this High Court will die.
No.
Then my orders will be null and void. So who is the party? Cooperative society. So he is the
The respondent number one is the plaintiff lordship.
appellant is the cooperative society.
No. The settlement executed in favor of the appellant. He is the defendant number one before the landed trial court lordship.
Who is the cooperative society? Where is the cooperative society?
The respondent number two is the death bench thing.
Lordship, he was in the capacity of secretary lordship.
Who was in the capacity of secretary?
Supreme Pandey.
Supreme Pandey. He filed the suit for cancellation of my salary lordship.
Okay. At the time when he filed the suit, he was very much the secretary
Yes.
at that point of time.
Yes. Yes.
भारत एकता गृह निर्माण सहयोग समिति. Is anybody appearing on behalf of respondent number one? You are appearing.
the respondent number Lordship is the PWC divorced before the elected trial court Lordship. Supreme Court.
What happened to the election dispute? What happened to the election dispute? You have no instructions. Sale deed was already registered.
Registered sale deed. Suit was filed with the respondent number for cancellation of my sale deed. I am the defendant number 1.
The suit has been allowed.
Yes, decree. Internal page 32. The suit is here by decree on contest. Internal page number 32.
For consideration of ₹1. That is a consideration amount. ₹1 में.
Society. There is a settled principle law is that non-payment of consideration amount include a ground for cancellation of security. The agreed person only ability to file money suit before the appropriate.
आपका यही पॉइंट है.
नहीं अभी ये पॉइंट नहीं बोल रहा मैं पेमेंट ऑफ कंसिडरेशन अमाउंट
हम भी जरा जानना चाहते
नहीं
हैं.
नहीं
आपका इतना ही पॉइंट है.
नहीं इतना ही पॉइंट नहीं है हम तो अभी पूरा पढ़े भी नहीं है अभी तो 41-27 के ही बहस कर रहे हैं
अभी क्या बहस करना है?
एक डेट को फिक्स कर दिया जाए हम लोग उसमें बहस कर सकते हैं उसमें
तो आज ही डेट है ना, चलिए ना बहस करिए.
आज तो 41-27
41-27 में क्या करना? वो आपका है रिकॉर्ड पे, कंसिडर करेंगे. पढ़िए, क्या बहस
आज तो हम लोग तैयार नहीं तो कल रख दीजिए कल हम पढ़ लेंगे
You want to respond to this? The learned counsel for the parties are present. IA number 10184 of 25 has been filed for adducing additional evidence. The learned counsel for the respondent pray for and is granted. How much time do you need? Till 9th of June to file a response to the interlocutory application. You are representing all the respondents? How about the other two? Other three? 2, 3 and 4?
For 4, they have filed an ID also for paper publication. They can't file this.
And 2 and 3 they have entered appearance.
They have to seek instruction regarding it.
service fee in the case respondent number 4.
As per the records of this case, the appeal was admitted on 12/4/2023. Counsel for the respondent number 1 is present. The records indicate that on 5th of February 2024, counsel for respondent number 2 and 3 were also present. As per order dated 10/9/2024, petition for substituted service of notice upon respondent number 4 was allowed. A supplementary affidavit has been कुछ पता नहीं है ना आपको, सब हमारा काम है देखने
नहीं
का।
मेरा काम है।
कुछ नहीं पता है,
नहीं मेरा काम की गलती हो गई है, हमारा काम है, ये मेरा काम है।
कुछ आपका काम नहीं है। ऐसे ही खाली तैयारी कर, टाइम पास वाला तैयारी।
हमारे टूल ऑफ सप्लीमेंट्री एफिडेविट
कहाँ है आपका सप्लीमेंट्री एफिडेविट, कब फाइल की? When did you file it?
25/10/2024. Flag A loss.
आप लोग के पास तो कोई काम भी नहीं है, तो फिर क्यों इस तरह से ये फ्लैग ऐसे कैसे रहता है?
ये रेट के नीचे रेट से ये लिखा है रेट ग्रीन।
The newspaper publication regarding substituted service of notice has been placed on record. Accordingly, the respondent number 4 has been duly served to substituted service of notice, which is accepted as valid. The service of notice is thus complete. ठीक है, कहानी अब IAS सब खत्म। और कौन कौन सा IAS में पेंडिंग है? IA number 10184 of 25 for additional evidence will be considered at the time of final hearing. और तो कोई IA नहीं
एक
है?
आईए से 174 माइनस 24
39,180 loss. 39,180.
वो सब IA का क्या ही मतलब है?
That may be also considered at the time of hearing.
The counsel for the appellant has submitted that the other application seeking under order 39,
Rule 1 and 2.
rule 1 and 2 be also considered at the time of hearing, and an appropriate date for final hearing be fixed. Record आ गया? now बताइए कब करना है? You tell us when do you want to do it? With the consent of the learned counsel for the parties, pose this case for final disposal on 18th of June. The learned counsel for the parties are directed to submit short synopsis of their argument along with the judgments which they seek to rely upon at least 1 week prior to the next date.
Item 4, FA 37 of 2023.
The office note below dated 2/5/26 may kindly look into. It points out that 1310, no person by this name lives in this area. So therefore my humble prayer would be, my Lord, to seek instruction from my client as to whereabouts of them.
FA number 37 of 2023. Respondent number 5 has been reported dead
Next is, our 5 died in the year 2025.
in the year
So I
2020.
will have to file a substitution petition relating the legal heirs and successors. So far they
Further,
have-
respondent number 1, 3 and 10 could not be traced. So far as respondent number 9 within bracket 1 to 9 within bracket 4 are concerned, they have been either served personally or through their close relative. The learned counsel for the appellant submits that the notice upon respondent number 91294 be accepted as valid. Considering the submissions, the notice upon respondent number 91294 is accepted as valid.
I only pray 6
With respect
time
to
and test.
respondent number 4, it has been served upon one Sobha Toppo, but relation has not been mentioned. In view of the aforesaid facts and circumstances, the counsel for the appellant prays for and is granted time till 15th of May.
6 weeks, my dear, it is because they are the tribal people to find out their real character.
By 30th of June to take fresh steps upon respondent number 1, 3, 10,
1, 3, 10.
1, 3, 4 and 10.
It is 3.
Sorry? 4 कॉपी तो नहीं सर्व हुआ for service of notice at their present and correct address
Yes, yes, my lord is correct. 1, 3, 4.
orderly process का फाइल करें। और कौन बचा? रेस्पोंडेंट नंबर 9 का सब्स्टिट्यूशन है, वो तो वैलिड सब हो गया। अब क्या करना है? रेस्पोंडेंट नंबर 9 हैज बीन सब्स्टिट्यूटेड।
नीचे ऑलरेडी सब्स्टिट्यूशन हो
अच्छा,
चुका है।
ऑलरेडी सब्स्टिट्यूटेड,
उसके बाद नोटिस हुआ था
9
9ABCD
ठीक है।
980%।
Lord, I'm appearing on behalf of responding number 2.
Respondent number, the learned counsel for the respondent number 2 is present.
And the 5G substitution petition is also required.
Post on 31st of July.
Item 5, FA 216 of 2023.
For the last date, NCR was not good. 1 week ago, I checked, but NCR had not come.
It has come.
Right now, I've checked the
So now,
क्या करना है?
I would pay for some time, maybe after vacations, I will
वेकेशन और 2-3 years आफ्टर वेकेशन हो सकता है। यहाँ तो 20 साल लगेगा इसको, अगर छोड़ देंगे 20 years के पहले टेकअप नहीं होगा। You have lost or you have won?
Lost.
You have lost. You are the plaintiff or the defendant? अच्छा 20 साल बाद टेकअप होगा फिर क्या? What was it for? Partition suit?
So, first of declaration of right again interest, it was their valuable land, and how it was dispute to that. So, deficit parties also. Sorry. The basis was on Sada 943, and receipt was 989. There was
कब करना है बोलिए? शुभ दिन मुहूर्त निकालिए।
If possible after vacation.
Which vacation?
Upcoming summer vacation.
Date कैलेंडर से date
Any day between 15 to 19.
The records from the concerned court has already been received. झारखंड स्टेट इलेक्ट्रिसिटी बोर्ड को आपको टेस्ट करना है। ये अभी यही जेसीबी से ही चलेगा कि क्या करिएगा इसमें? हाउ डू वी नो? ये सब तो कुछ अमेंडमेंट कुछ नहीं आया है। Also for the respondents are present. कब रख दें बताइए? With the consent of the learned counsel for the parties, pose this case
Immediate of the
on
any date after vacation.
June for final disposal. The parties are directed to prepare their short synopsis of argument and also submit the judgments which they may seek to rely upon. हुक्मनामा है आपका, followed by rent receipt.
that was of 1989. So, the number is of 43.
Without the
तो सरकारी आदमी ने रेंट रिसीट इशू किए हैं, इसको क्या डिस्कस कर दिए? हाँ?
Item 6, April 106 of 2024.
Yes, please.
Those who are moderated 24/9, those already notices have been issued, but none is done on behalf of the respondent. And there is an item was 12329/24. And the now
आपको तो डीएफटी भी एक बार हो गया था ना?
He was that has been restored, and thereafter.
Notices have been
Yes.
issued when?
By order dated 4/12/2024 in the original records. And now to this IA 12329 of the 2024 for limitation.
Requisites were not filed.
It has been filed.
No. In terms of that order, the requisites were not filed. That is why case was dismissed for default.
Yes, yes, yes. That requisites were, that's the reason it has been reappealed also.
So how do you say the notices were issued and nobody has appeared?
That I will find but more acceptance. More acceptance.
Where is the order of restoration?
CMP number is 606 of
दिखाइए जरा। This appeal was dismissed on account of non-compliance of order dated 4/12/2024, whereby notice was issued upon the respondents. However, the same has been restored by virtue of order dated 10/10/2025, passed with CMP number 606 of 2025. Let notice be issued upon the respondents, both in the interlocutory application seeking condonation of delay of only 32 days and also in the main appeal under speed post and also through ordinary process, for which recusals be filed within a period of 1 week. दोनों का इसलिए कर दे रहे हैं, ओनली 32 डेज है, फिर नहीं तो दोबारा नोटिस करना पड़ेगा. 32 डेज तो जनरली कंट्रोल हो जाए. If there is any objection, then we will reject it on the point of limitation also. दोनों में कर दे रहे हैं, बार बार करने से क्या पोस्ट ऑन 31st of July. Awaiting service.
Item 7, Apply 11/4/2024.
Layer notice 60 also.
Notices were issued.
Those are allowed these like basic works. I have done that.
Notice has been served. Why is it listed for orders? Why is it listed for orders?
No, it's 24 of the recommended number 24 that this is sometime.
IFI.
Yes.
And pursuant to order dated 7/11/2025, notice was issued, and as per office note, notice upon respondent number 12, 22, 32, 14, 18, 19 have been served either personally or through their close relative. Accordingly, the notice upon respondent number 12, 22, 32, 14, 18, 19 is accepted as validly served. Respondent number 1 to 9, 13, 15 to 17 have already entered appearance by filing wakalatnama. And notice upon respondent number 10, 11, 20, 21, 23, 26, 27, 28, 29, 30, 31, 33 was already accepted as valid as per order dated 7/11/2025. Counsel for the appellant has submitted that a petition for substitution of respondent number
24.
24 has been filed, being IA number. IA number
Item
not for
7.
substitution. For deletion of respondent number 24 has been filed through IA number 13388. ये pending है ना? 13388.
नहीं लेट्स पेंडिंग नहीं हो पेंडिंग मेरे पास सिर्फ लिमिटेशन मैटर पे 3867 ऑफ 2025
ये डिलीशन के लिए फाइल हुआ था, ये किस लिए फाइल हुआ? There was a petition to file to delete the name that has been, what have been done to that? Oh. That was dismissed. अच्छा, ठीक है. The learned counsel for the appellant has submitted that respondent number 24 has expired. For which IA number 13388 of 25 was filed to delete his name. But since the date of death was not mentioned, the IA was dismissed. The learned counsel prays for attorney. कितना टाइम चाहिए? At his request, place this case on 16th of June.
Item 8 FF 45 of 2025
Last week, press notices were directed to be issued to 10, respondent number 10, 13 and 1. 10 has received by his son, 13 personally, and it has come that 14 has died prior to execution of this present deed.
FA number 45 of 2025. As per office note, the respondent number 10 has been served through her son, and respondent number 13 has received it personally. And so far as respondent number 14 is concerned, he is said to have expired on 13/11/2022 prior to filing of this first appeal. Counsel for the appellant submits that the notice upon respondent number 10 and 13 may be accepted as validly served, and he seeks adjournment. Considering the submissions, the notice upon respondent number 10 and 13 is accepted as validly served. So far as respondent number 14 is concerned, और इसमें कुछ नहीं. कब चाहिए आपको?
Second week of 16th या 17th?
The learned counsel for the appellant prays that the matter be posted on 16th. Post on 16th.
Item 9 FF 56 of 2025
Respondent number 1. Fresh वकालतनामा. Respondent number 2 has been served notice through his office clerk. Respondent number 1 has been served notice through her husband. The notice upon respondent number 1 and 2 is accepted as valid. The learned counsel for the respondent number 1, Mr. Rajesh Kumar, submits that he shall file वकालतनामा on behalf of respondent number 1. Delay में क्या बोलना 19 days. The learned counsel for the petition submits that appellant submits that IA number 3105 of 25 has been filed seeking coordination of delay of 19 days in filing the present appeal. Counsel for the respondents has no serious objection so far as the prayer for combination of delay of only 19 days is concerned. After hearing the counsel for the parties and being satisfied with the fraud shown in the interlocutory application, ID number 3105/25 seeking condonation of delay is hereby allowed. Formally admit कर लें? Admit कर लेते हैं? Admit you will file wakalatnama in how many days?
By Wednesday,
The respondent number 1, the approached counsel has undertaken to file wakalatnama of respondent number 1 by Wednesday. Call for records from the concerned court. So far as respondent number 2 is concerned, the record are here. The records from the concerned court has already been received. So far as respondent number 2 is concerned, nobody is appearing. Office is directed to forward a copy of this order to the Office of Learned Advocate General so that an appropriate counsel is deputed to represent the respondent number 2 in this case. It was a suit for
Cancellation of
sale.
Yes, ma'am.
On what ground?
Now cancellation amount,
No consideration.
no cancellation.
Future consideration दिखा कि नहीं?
सर कुछ भी नहीं खाया मगर इसको सडनली ये she was my tenant lot and I'm 76 year old person. Suddenly she has obtained my signature in various papers. On that basis she obtained permission from
When do you want to do it? कब करना?
after vacation.
With the consent of the learned counsel for the parties, post this case for final disposal on 27 days. The parties to prepare short synopsis of their arguments and also submit judgments which they seek to deliver.
Item 10, FA 57 of 2025.
There are two areas in leadership. One is for substitution and another is for condonation of delay.
How much is the delay?
2,686 days.
2,686 days.
Yes.
Who died when?
Respondent number 1 died in 5/11/2017.
5/11/17. This is prior to filing of the appeal.
Yes.
So how the substitution is maintained?
It is because it was proceeded with ex parte and we were only made aware of the knowledge about his death through the service report when this first appeal was admitted. It was admitted on 15/7/2025 and we got knowledge on 3/12/25. It was posted for us.
This is respondent number 1,
Yes.
right? You are the plaintiff or the defendant in the suit?
I was plaintiff.
So if we add them party at this stage, They have a right to contest. Then the matter will have to be remanded to the court. Yes? WS तो नहीं फाइल किया. The proceeding was ex parte against
It
them.
was proceeded ex parte and decree and judgment was made ex parte.
So the remand भी क्या ही होगा? The by which order it was rendered ex parte? It must be there in the order itself. By which order it was rendered ex parte? Para 3 पढ़ी, page 36, page 30.
वर्तमान वाद में वादी के द्वारा प्रतिवादी जन के उपस्थिति हेतु सामान्य नोटिस की कार्रवाई करने के पश्चात प्रतिवादी 1 से 5 तक दिनांक 3-6-15 को उपस्थित हुए और अपना करने हेतु समय की मांग की थी, लेकिन उनकी ओर से कोई लिखित कथन नहीं दाखिल किया गया. तत्पश्चात 17-10-2015 को लिखित कथन दाखिल करने से वंचित कर दिया गया. तत्पश्चात वादी द्वारा कोई कार्रवाई नहीं करने के कारण मूल वाद को दिनांक 20/7/2016 को कदम पैरवी के वाद को खारिज कर दिया गया, जिसे दिनांक 18/3/2019 को आदेश से पुनः जीवित किया गया. अभिलेख के अवलोकन से ये स्पष्ट होता है कि दिनांक 13/6/2023 के आदेश से सभी प्रतिवादियों के विरुद्ध एक पक्षीय कार्रवाई आरंभ कर दिया गया, क्योंकि वाद का पुनर्जीवित होने के बाद प्रतिवादीगण की उपस्थिति हेतु सभी कार्रवाई के पश्चात भी उपस्थित नहीं हुए. तत्पश्चात ये अभिलेख स्थानांतरण के बाद इस मामले में प्राप्त हुआ.
Dismiss होने के बाद it was dismissed on 27/2016 and before it was restored he died. At the stage of restoration no notice was issued. देखिए IA number 370 of 2026 and IA number 371 of 2026. IA number 370 of 26 has been filed seeking substitution of respondent number 1, namely Abdul Rauf Khan, who is said to have expired on 5/11/2017. The learned counsel has submitted that a petition seeking condonation of delay of 2628 days has also been filed. He has further submitted that the judgment and decree passed on 18/9/2024 was ex parte and the suit was instituted on 6/12/2014. And only upon issuance of notice in the first appeal, the appellants came to know that respondent number 1 has expired. The names of legal heirs and successors have been mentioned in paragraph 10 of the interlocutory application. The impugn judgment further reveals that the suit was filed and notice was issued, and the defendant number 1 to 5, including the respondent number 1 herein, had appeared and filed wakalatnama. However, their right to file written statement was closed by the order dated 17/10/25. The suit was dismissed for default on 27/2016 and was restored on 18/3/2019. And it appears that in the meantime, the respondent number 1 hearing, who was a defendant number 1 in the suit, had expired. ऊपर ही लिखी हुई है. Issue notice to the proposed legal heirs and successors of respondent number 1 in IA number 370 of 2026 and also IA number 371 of 2026. For which requisites to the proposed legal heirs and successors, whose detail has been mentioned in paragraph 10 of IA number 370 of 2026. Through the concerned police station, for which requisites be filed by the appellant within a period of latest by 14th of May. Post this case on 30th of June, awaiting service report. इसका जरा दिखाइए इसमें. कौन है आपके सीनियर?
मिस्टर राहुल कुमार दास.
राहुल कुमार दास. नहीं पहचाना. Office is directed to call for the records of miscellaneous case number 4 of 2017, which is related to title suit number 570 of 2014, as mentioned in the order dated 23/4/2019/4/6/2019 of the learned trial court's record. From the concerned court. Let this order be communicated to justice. आपका केस है मिस्टर शर्मा?
Item 11 F82/2025.
What is it all about?
In this case, notice is the issue. On office notice, the loading party issued my time say the last one was 4, 13, 17, 19, 25, 25, 28,
क्या चाहते हैं आप ये बताइए ना, अभी शॉर्ट टाइम में क्या हो सकता है बताइए, क्या चाहते हैं? The notice should be accepted as valid. बताइए किसका किसका valid?
इसमें तो खुद ऑफिस नोट आया।
Okay, लिखते हैं पूरा. As per office note, respondent number 1 to 3, 5 to 12, 4, 16, 39 to 41, 43, 44, 58 to 63 have already appeared by filing. Respondent number 17, 19 to 23, 28, 52 and 55 have been served personally. The notice is accepted as valid. Respondent number 4, 13, 25 to 27, 30, 31, 33, 34, 42, 53, 54, 56 and 57 have been served through brother. Respondent number 18 through daughter. Respondent number 32 through her son. Respondent number 35 to 39, 45 to 14, respondent number 32 through her son. The learned counsel for the appellant has submitted that the notice upon the aforesaid respondents be accepted as validly served. Considering the submissions, the notice having been served upon through close relative, the notice is accepted as validly served. Not return unserved.
With the return answer, then 45 to 48 also return answer. We had filed an application for that is also on board. A number 401.
Just a moment. Respondent number 15, 24 and 29 have been reported dead.
Then I will let it.
Respondent number 35 to 39, 45 to 48 and 49 to 51 could not be served. The learned counsel for the appellant prays for and is granted 4 weeks time to take fresh steps.
51, I will be taking steps.
सारा रिटर्न आंसर सभी का करना पड़ेगा.
इसका तो
डेट का तो है 15, 24 and 29. डेट के चलते नहीं, outside the territorial jurisdiction. वो
outside, it is not outside. I have seen the
49 to 51. वेस्ट बंगाल का है सर. नहीं, प्रेजेंट एड्रेस दिया हुआ है, आउटसाइड जुरिस्डिक्शन है ना, तो ये लोग आपको स्पीड पोस्ट से सर्व करेंगे. फॉर टेकिंग फ्रेश स्टेप्स फॉर सर्विस ऑफ नोटिस अपॉन रिस्पॉन्ड नंबर 35 to 39, 45 to 48, 49 to 51 at their present and correct address through speed post, for which recusals be filed within a period of 4 weeks from today. Office to track speed post delivery. Why are you seeking exemption for substitution? Exemption for substitution.
Yes, I had filed this because the defect was pointed out. That petition I have filed.
We'll see that later. Let others appear. If you want to file any objection to this, you can. How about you? You are representing the contesting parties?
5, 6, 7, 8, 9, 10.
That's right. Do you want to file any reply to the pending interlocutory applications?
I have filed 2 applications. One is for that is 10289 of 24. It was for ignoring defect because I have already met them party. So, but I was seeking leave that then I may be allowed to pursue with them. And second one, when the office had pointed out this defect, I have filed an application under order 22 rule 44 because they did not contest with the report. And the 22.44 says, if you did not you have not contested with the ex party, then if exemption is granted, then it is valid against their legal reasons. And because those petitions, both the petitions are there on board.
Even if a person does not, even if the proceeding is expired, it is one thing to say that you are unable to secure their appearance.
No, I agree to that.
There could be a situation they may come and assist that on the basis of materials also no case is made out. So we need their assistance. We cannot exempt you from it.
That is what I was saying. That is the reason my lord has issued notice in both the petitions.
Notice has been issued.
Both the petitions, my lord may kindly.
Then what happened? Ultimately, this is a service note on with regard to both these petitions.
Yes. You may kindly see the order.
The case has not yet been admitted so far.
Because of the address, 35 to 39 has not been solved.
You serve them through speed post and then we will see what is to be done.
Respondent number 60 has also died in the meanwhile on 25th of September 25.
Respondent number?
60.
60. It has been reported by the learned counsel for the respondent that respondent number 60 has expired on
25/9/25.
25/9/25. Post on 13th of July.